Today we are going to talk about whether it is possible for someone to lose British citizenship even after naturalization or registration. The question remains yes or no, and by the end of this conversation, you will have the answer to give. We are looking at instances where individuals have gone through the process and have become British citizens. And there are different routes to citizenship. Regardless of the route you have taken, what's important is that you've gotten to the point where the Secretary of State has accepted and granted you citizenship right, with the effect that you may even have acquired passport. At this point, has the Secretary of State any power to change her mind and take that citizenship right from you, or even cancel the passport? The law in question is the British Nationality Act 1981, and our reference is Section 40. The provision is clear that the Secretary of State may, and this is a discretionary power, take steps to revoke or deprive someone of their citizenship once the Secretary of State has found out that at the time of application, these three issues were present, but her mind was not on that. These issues include fraud. Therefore, if the application was made fraudulently, based on which the right was granted, the Secretary of State has the power to deprive the individual at this stage of the citizenship right. Or if the application involved use of misrepresentation of fact or information so that the application was accepted and it is found out, then the Secretary of State will rely on that power she has under the law to deprive you of that right. Again, if at the time of application it is found out later that you concealed material fact or relevant information pertinent to the application, the Secretary of State has same power under the law to deprive you of your citizenship. So answer to the question is yes, depending on the circumstance. So at this point, what will the Secretary of State do? The Secretary of State will have to invite you to respond to the allegation that they have found something that is in breach of the law, and that if they had knowledge of this at the time of application, that application would not have been granted. And at this point, you have the opportunity to express yourself, to explain what they are alleging, of course, to the effect that you deny and you support, if any, evidence that you may have. The Secretary of State will then leave the matter at that point if the explanation is satisfactory, or proceed to the next stage with a view to notify you of deprivation if the Secretary of State still feels that the explanation is not satisfactory enough. Once you have been notified that revocation or deprivation action is to be taken, what can you do? The Secretary of State still has the power, still has the obligation to give you the appeal right so that you can take it further, i.e. to court, to be able to be heard in terms of fairness and justice. And at that point, you can appeal against that decision to revoke your citizenship right. What we are saying here is this. If you are stateless, that means there's no way you have a country to go to, then the Secretary of State will not, even with that power, be able to ask you to leave the UK. In all this, we advise that please do see a solicitor who understands the provisions of the law. BWF Solicitors is available to always attend to your needs. Come to us whenever you receive a letter. Don't panic. Come to us. We'll be able to work with you to offer the explanation the Secretary of State wants. But the position remains that once you are granted, it is not the end of the world, and they can ask you for further evidence to support why your right should remain.